All right. Welcome to our Summer Associate Series webinar from Deal to Dispute, Dispute Resolution and Practice. I am Ryan Frome-Pizzulli, Program Manager for the Institute for Energy Law, which is an institute of the Center for American and International Law. Today's webinar is hosted by the Program Subcommittee of IEL's Young Energy Professionals Practice Committee. This is the second webinar in a two-part series designed for summer associates. I would like to thank IEL's online learning sponsor, Baker Bots. Its annual support of all of our programs allows us to make this program free for IEL members and for law students. Our speakers today are Aamir Siddik and Hamza Yazdani. Aamir is an energy litigator at Vinson and Elkins, LLP in Houston, where he works with companies in the oil, gas, electricity, and renewables industries to resolve business disputes. He was in IEL's 7th leadership class. And Hamza is an of counsel at Gibson Dunn in their Houston office, where he works on energy transactions. He was in the 6th leadership class and was awarded IEL's Emerging Star Award in 2024. I will now pass it over to them for their presentation.
Thanks so much, Ryan. We're going to get started in just a second here. Welcome, everyone. We're excited to be presenting to you all. We're excited to be talking with you all. We want this to be a little bit more conversational, and I realize that it's difficult to be conversational when we can't see you, but feel free as we're kind of talking through the materials that we've prepared for today. If you have any questions for us, feel free to drop them in the chat. We'll get to them as we're going. We want to make sure that we're providing value to all of you. We understand that many of you are law students, and while we have prepared things that we think might be of interest to you, we also want to take the conversation to whatever you might be interested in, whatever value that we can provide for you.
Couldn't agree more there, Aamir. We've sort of, formulated the presentation based on what we think would be useful for you, but really we want to add value to whatever you all are thinking and those burning questions that you might have. So as without further ado, I'll get started. I'm Hamza Yazdani. I work at Gibson Dunn, and I'm primarily work on energy transactions from a transactional perspective. And so what does that mean? That means at a high level, we help clients do business deals. That means buying or selling a company or an asset, investing in a business, forming a joint venture, developing a project, raising financing, entering into long-term commercial arrangements, or restructuring an existing relationship. Now, the easiest way to think about this is that litigators are often involved when a relationship has broken down, whereas transactional attorneys come in when parties are trying to create, expand, finance, or exit a relationship. And now, so our job is to help the client get from a business objective to a legally enforceable arrangement. And so that means understanding the commercial deal, identifying risks, allocating those risks. You'll hear me use that phrase a lot, allocate risk in those documents. And then negotiating with the other side, coordinating with specialists, which mean your regulatory people, your environmental people, insurance people, and getting the transaction signed and closed. Now, a big part of the work that I do as a transaction attorney is drafting, which means translating business points into legal rights and obligations. Who has to do what, by when, what happens if they do not, who bears the risks, which risks do parties bear, what approvals are needed, what conditions have to be satisfied before closing, and what remedies does our client have in case something goes wrong. So as a transaction attorney, you're doing both legal as well as commercial work. And so you're not just figuring out, is this clause legally correct or legally enforceable? You're also asking, does this clause reflect the business deal, protect the client, and work in the real world? In terms of documents that we work on or I work on, I'll categorize them in 4 buckets. The first are the preliminary documents, the preliminary agreement, the confidentiality agreement, the letter of intent, the exclusivity agreement, term sheet. Those documents really set the framework for the parties to exchange information and negotiate and be comfortable that even if those preliminary conversations do not lead to a deal, that they would not be over leveraged. They wouldn't spend more money than they need to. They wouldn't be disclosing more information than they need to. And whatever information they actually disclose, that is in a lockbox, in a black box that nobody else can access. Second are the main transaction documents. So in an M&A deal, that might be the purchase agreement, the merger agreement, the membership interest purchase agreement, the asset purchase agreement. These documents really set out the core bargain of the parties, what is being bought or sold, the purchase price, the reps and warranties, the covenants, the closing conditions, termination rights, indemnities, remedies, dispute resolution. Third bucket would be the ancillary documents. These are the documents needed to make the transaction actually work. It might include an assignment agreement, transition services agreement, escrow agreement, disclosure schedules, officer certificates, legal opinions, consents, which as a junior lawyer, you'll be working a lot on, closing deliverable, board approvals, and notices. Fourth bucket would, especially in the project development context or energy transactions, would be an entire suite of commercial and project documents. That means the JV document, the development agreement, the EPC contract, the O&M agreement, power purchase agreements, interconnection, site leases, offtake agreements, fuel supply agreements, transportation documents, financing documents, tax credit, transfer agreements, anything to make sure that those electrons or molecules can be generated, transported, off-taken, and whatever that would entail. And so one of the things that makes our job so interesting and intriguing is that it's like you're solving a puzzle. That's what makes this deal work so interesting, that these documents really have to jive together. They have to fit together. You can't just draft each document in isolation. You really have to understand how the whole structure works, where the risks sit, which party bears those risks, and which party has the credit worthiness to bear those risks. And then what happens if one of the project or transaction does not perform as expected? And so we'll continue to talk about this more, but really in an M&A, in the energy space, you can really choose your own adventure. You can be in the M&A space. You can be in the private equity space where you are investing in already established projects. Or you can work on the project development side, which is really picks and shovels. And that is very interesting as well. And obviously, like as I mentioned, there are a lot of ancillary documents that go in there as well. The energy company might be doing an IPO. The energy company might need to raise debt. So you see a whole suite of documents within the energy space. And then the final would be the project development, where you need long-term commercial agreements such as power purchase agreement, offtake documents, transportation documents, and services agreements. And so this is really why energy deal work connects so naturally to disputes, because if a project is delayed, if a permit is challenged, if a counterparty does not deliver, if the financing assumptions change or the market conditions have shifted, because these are long lead items generally, the parties will look back to the documents to see who bears the risk and what remedy is available. So for a transactional lawyer in the energy space, the goal is not just to get the deal signed. The goal is to build documents that reflect the commercial bargain and ensure that they can withstand stress if the project relationship does not go exactly as planned. And I think that sort of is a nice segue for Aamir to talk about the energy disputes and how he sides his side of the practice.
Thanks, Hamza. That was awesome. So before I get started into my specific practice, I want to kind of expand on something that Hamza was saying, is that Hamza's job is to allocate risk. And in any given deal situation where there's contract or multiple contracts or agreements involved, we're ultimately taking as you've learned in law school in your contracts class, the meeting of the minds, the idea of the deal and reducing it down to words. And at some level, a contract's never going to perfectly encapsulate every single thing that the parties intended or wanted to be a part of that deal. And there's always going to be some room where parties might disagree on fair readings of that interpretation. But ultimately, that's all we've got. We've got words reduced to a piece of paper or pieces of paper that are trying to explain what the deal is and what money's being moved where, what parties need to do what are your rights, what are your obligations, and managing risk within that framework. As a litigator, we come in when something's gone wrong. So while Hamza allocates risk, we kind of come in and manage risk. So litigation in general, I mean, y'all are law students. You've probably been exposed to various case law. You've probably taken civil procedure. You've seen a little bit more of the litigation side of the practice than you might have seen of the transactional side of the practice. But one thing that going through law school you can often miss is the ultimate advising on risk portion of this. Yes, as a litigator, I handle lawsuits. I'm in state and federal court. I'm often in arbitration, which are just privatized courts that the parties pay for to handle the disputes. But throughout that entire process, we're always looking for solutions where our client can be in their most advantageous position. That might not be going to trial. That might be coming to some sort of commercial arrangement with the other party, because inevitably the energy space can be kind of small. You're going to be working with the same counterparties over and over again, because in this industry, you need to work together at some level in order for everyone to succeed. So we're going to be, as litigators in a contract dispute, we're going to be looking at the contract language. We're going to be advising the client on that contract language. We're going to be proceeding with a lawsuit if that's necessary, and if necessary, taking that to trial. But we're always going to be helping our client understand the risks involved with their position. Because inevitably, at this level in the energy space, there's never clear answers. And there's always some level of risk, especially if in the lawsuit process, that no matter how clear cut of a case you might have, there's always a risk that you might lose, or that the judge might not see it the way you see it, or that the jury might not see it the way that you see it. So throughout the entire process, we're always keeping the business objectives of our client in mind as we move forward with a lawsuit, or as we're advising a client in a dispute that's in its initial formation, but isn't yet at a point where we might be thinking about filing a lawsuit. And as mentioned earlier, look, I work in the energy space. I do a lot of oil and gas work. A lot of my work is contractually based, but there is often, I mean, the oil and gas space has some inherent amount of danger. Working with pipelines, there's always a risk that something goes wrong with a pipeline, it explodes, it hurts people. Even just the process of extracting minerals from the earth is inherently dangerous and things can go wrong. So we're always advising our clients of the potential risks involved there and the potential for people getting hurt, and then who bears that risk when that happens. Now we want to move a little bit to kind of where Hamza and I's practice intersects, and the areas where you might find deal lawyers and litigators working together. Hamza, would you mind talking a little bit about, I mean, as a start, when you're drafting these commercial deals, expanding a little bit more about how you're allocating risk and kind of the key things that you're thinking about when doing so? Hamza, I think you're on mute.
Thanks. 6 years and we continue to face these issues with Zoom. Great question, Aamir. I would I want to build off of what you said, which is it is impossible for our collective minds to figure out the future and build every single risk there is, especially in energy transactions, which are very politically charged, number one, Number two, there's a lot of geopolitics involved. And number three are typically very long agreements. Your typical molecule offtake or a power purchase agreement or a energy infrastructure build out agreement would be around 20 to 30 years project, all the way from figuring out your contractor to building the project, and then those molecules or electrons being off taken. And so you mentioned pipeline. I would, as a case study, mention Nextera's transmission line, MARL, which is Mid-Atlantic Resiliency Link, which is a 100-mile transmission line from Pennsylvania, and I want to say it ends in Virginia. And so at the time when it was approved by PJM, there was no ChatGPT. And now all of a sudden, with the grid being constrained with so much demand, all of a sudden the questions that were before the docket in 2022 have completely changed to what they are now. Similarly, if you were working on an energy project in 2024, 2025, you were negotiating documents or had just finished negotiating documents, and all of a sudden the issue of tariffs became so salient. And who bears that risk? Because the costs have gone up. And so how are you allocating that risk? And so just to, and the reason I bring these two issues is because these, like development of ChatGPT or tariffs, these are black swan event. There is no way we could have identified those risks and allocated them adequately, or thought about those issues in a document. And so one of the most important things as a transactional attorney you can do is to draft with that bad day in mind, or thinking about those hell in a handbasket situations, and allocating risks accordingly. Most deals are negotiated in an optimistic environment. The parties want to get deals done ASAP. They want to share the good news with their shareholders or the owners. They want to maintain a good relationship. And so, they may be reluctant to bring up these difficult conversations early on, even, because they're commercially aligned and they don't want to get in they don't want to malign the relationship this early on. But, and ideally you want to sign the document, put it in a drawer, forget about it. But that's not what happens in the real world. And so really, the contract gets tested when something goes wrong, when the project is delayed, when a counterparty does not perform, when market conditions change, or when the parties remember the deal differently 6 months to 12 months later. So when I'm drafting, Aamir, I try to ask a few practical questions. Number one, is the obligation clear? Who has to do what, by when, to what standard, and what happens if they do not do it? And so a lot of disputes really come from provisions that sound reasonable at the time, but are not specific enough when applied later. What does it mean promptly? Does that mean tomorrow? Does that mean in 6 months? What does commercially reasonable effort means? What does a prudent industry operator mean? What does the word material mean? And so, these words sound great, but they can also create room for disagreement if the parties have not really thought through what they mean in the context of the transaction. And sometimes you do want flexibilities. You do not want to be too prescriptive either. And so that does not mean that every provision needs to be hyper detailed. Sometimes you need flexibility. That flexibility is intentional, but the party should understand what they're accepting. And if certainty is important to either party, we need to be more specific. Number two, I would say, don't try and be sneaky. It's important to have these difficult conversations early on, and be, very specific about the obvious failure scenarios. So what happens if the interconnection is delayed? What happens if the permit is challenged? What happens if the antitrust regulatory approval is not granted? What happens if CFIUS comes back and says, oh, well, this transaction should never have happened? What happens if commercial operation is missed? And so while you do not need to predict every possible problem, you do want the contract to address the risks that are most likely to matter. And the last thing I would say is, especially for junior lawyers, be careful with boilerplate. You'll see senior lawyers being very particular about for example, in an M&A transaction with the purchase price adjustment and what happens at closing. And so as a junior lawyer, I think you can really add value by focusing on the boilerplate. They have a bad reputation because they normally are at the end of the contract. Nobody's paying a lot of attention to them, definitely not the commercial parties, but governing law, forum selection, arbitration, notices, assignments, remedies, limitation of liability, indemnification, non-reliance, these provisions are super important. And so, for example, sanctions and tariffs, like you want to make sure those are adequately covered in force majeure. Or take limitations of liability, like a broad exclusion of consequential damages may look standard, and you may look at other precedent documents, but your scenario might have changed, or if it's in a different time period, you want to make sure that what you're tailoring the contract to the current market. And so what we occasionally do, or frequently do, is that we reach out to our litigators like Aamir to see whether or not our provisions are litigation proof or bankruptcy proof. And so litigators can be very helpful before there's a dispute, especially when the provision is likely to matter if the deal comes under stress. And so we would consider involving litigators when we're drafting dispute resolution provisions, and we would also involve them in specific performance provisions, fraud, non-reliance, indemnity structures, limitation of liability, consequential damages waivers. Bringing them on early sort of helps you figure out if the governing law or the dispute resolution is a Delaware law, how would a Delaware judge think about those issues? Or how would an arbitrator think about those issues? And I think the biggest value for a litigator would be to spot procedural issues early on, whether related claims can even be brought in the same forum, whether all necessary parties are bound by the same dispute resolution mechanism or not, and whether our client would be in a position to get interim relief quickly or not. And so, again, I think sounding like a broken record at this point, but like the goal is not to eliminate every possible dispute. That is not realistic. The goal is to make parties' rights and obligations clear enough that if a dispute rises, the path forward is predictable and the remedies are commercially meaningful. And if there's one thing that I would like you to leave with is, especially now in this day and age of AI, good drafting is not just about making the agreement look polished. Polish used to be like a big value add. Now polish is very cheap. Even things that lack substance can look very polished. It's very important as a junior lawyer to be asking questions and figuring out how does the complete structure work, the piece you're working on, where does that piece fit? And then make sure that the contract works when it's under stress and where parties are disputing a clause. But yeah, I mean, would love to hear your thoughts about some of the situations where, transactional attorneys might bring you in.
Yeah. I mean, before I get there, one of the things that is really tough about your job is that you're having to think about some of these disputes in the abstract. You're kind of thinking about what could potentially go wrong, and you're having to think about the entire universe that might be out there of what could possibly go wrong, and you're not necessarily nothing's gone wrong yet. You're not necessarily thinking about something specific. You're having to think about every possibility that might be out there, and hopefully the contract has it covered. Whereas I'm generally being brought in once something has gone wrong. Now, in addition to that, there's a small portion of our practice. I mean, similar to your firm at Gibson Dunn, Vinson Elkins is also a full service firm where we've got transactional folks, we've also got litigators, and a small portion of our practice consists of being brought in by our transactional attorneys to advise on deals specifically. So that might look like, say, one of our clients is acquiring a business, and there's a number of lawsuits or potential lawsuits out there that the business might be subject to over the coming years, and advising the acquiring party on the total amount of risk there. Because ultimately, if you're acquiring a business, you want to know the risk that you might be taking on, or if that risk needs to be allocated elsewhere, you want to be able to have the option to do that. You don't want to acquire the business and then suddenly get stuck with millions of dollars of lawsuits that you had no idea were coming. You want to at least be thinking about it and be able to be proactive about it. So sometimes we'll get brought in at the deal stage to advise on things like that. Or like you mentioned, we might be consulted on specific provisions that might end up having consequences if there's ever a dispute about this, whether that's an arbitration provision, a choice of law provision, a venue provision. There's a lot of agreements that I've seen that have more complex dispute resolution mechanisms. So that might consist of, say, the initial dispute. If there's a dispute over the agreement, you might have a 30 or 60-day window in which the executives from the companies come together and try to resolve it themselves. And if that doesn't work, they go to mediation. And then finally, if that doesn't work, it might go to a lawsuit or an arbitration, and advising on that kind of an issue, or advising on, okay, what choice of law might be favorable if something were to go wrong with this contract. Not necessarily anything specific at this stage, because it's still in the deal framework, but what choice of law might be overall favorable if something goes wrong here. And then we always have situations where, let's say there's a deal that our transactional folks have worked through, and now something's starting to go wrong. That might also be a situation where the litigators get brought in to advise on the client. Maybe it's not at a stage where we might be filing a lawsuit yet, but we want to make sure that we're preserving all of our rights and obligations under the agreement at this stage, to make sure if it does proceed to a lawsuit, we haven't done anything to mess up our claim. Yeah, because there's a lot that you can do to either waive your rights or hurt your rights before a lawsuit is filed. So we might advise on that. And then finally, if things do proceed to that level, we might be involved in filing a lawsuit or filing an arbitration claim and kind of moving forward with the investigation part of that and telling our client's story for why they're in the right on this given dispute. Now, I mentioned this a little bit before, and something that we always want to be cognizant of is that our client is a business and that they have certain business objectives in mind. Those business objectives might not consist of taking a case to trial and winning a trial. This might be a counterparty that we're having a dispute with that we might want to continue working together with. And while in theory you don't want to mix business and personal, there's always a certain amount of feelings involved, especially if a party that you're working with on a consistent basis goes and gets a $100 million judgment against you. So you always want to be mindful of the total business objectives of your client, and whether or not the route that you're taking, whether that's through a lawsuit or through arbitration, whether that's in mind with your client's objectives for their business. I mentioned a little bit about dispute resolution clauses. And I know, Hamza, you're involved in drafting kind of a lot of these dispute resolution clauses. Can you talk through kind of your thoughts on when you're drafting? Well, I mentioned this briefly, but at a high level, talk about what a dispute resolution clause does. And then can you talk about what your key considerations are when you're drafting a clause like this? And how do you think about any sort of alternative dispute resolution mechanisms? And how do you think about kind of these choice of law, choice of venue kind of considerations?
Yeah, absolutely. I think I touched upon this early on as well. I think what makes dispute resolution provisions tricky is that they appear, or they're considered boilerplate, and the commercial teams aren't focused on it. And so you want to make sure, especially when you're a junior lawyer and you're preparing an issues list, that in the issues list, you sort of highlight for the commercial team, for your senior lawyer, the dispute resolution / governing law. They sort of go hand in hand, Aamir. That they should not be treated as boilerplate, and parties are very intentional about each and every specific procedural issue. They often appear at the back of the document, so it's easy to think of them as standard legal language, but they can be very commercial. And so you do not pick arbitration, litigation, expert determination, mediation in an abstract. You ask, what disputes are likely, how urgent are they, how technical are they, do the parties need confidentiality, where are the assets, where are the parties, what are the remedies that would actually matter? And all of those questions, there's no one glove fits all here. All of these questions would be tailored to the document, to the provisions, to the transaction that you're working on. And so if you answer those questions up front, the dispute resolution provision becomes much more than a routine boilerplate, and it becomes part of that risk allocation architecture of the deal. And so when I'm drafting a dispute resolution provision, to answer your question, Aamir, I usually start with a practical question. If this deal breaks, what kinds of disputes are most likely to arise? And that question should really drive the process, because that would differ in an M&A transaction versus a project development transaction. So, for example, if you're drafting an M&A agreement, certain disputes may be accounting or calculation disputes. They would not be adequate to be, adjudicated before a judge sitting in, I don't know, Montgomery County, working capital, net debt, earnouts, purchase price adjustments. They may be better suited for expert determination rather than full-blown, litigation or arbitration. As I mentioned, you can't have a one glove fits all. So other disputes are different. If the issue is fraud, if it's failure to close, breach of a covenant, breach of a rep, which has completely and materially changed the economics of the deal, then the client may need a court or an arbitral tribunal, and may possibly need emergency or equitable relief. I'm pretty sure you probably hit on those issues in your section. Now, in a project development context, the analysis may be different. Some disputes are legal disputes, some are technical, some are operational. Now, if the fight is whether a facility met a technical performance standard, maybe you want a technical expert. If the fight is whether a party can terminate, whether force majeure applies, whether a sponsor failed to fund, you might want arbitration or litigation. So I tend to think of the ADR, which is alternative dispute resolution, as a toolbox: mediation, expert determination, arbitration, escalation procedures. They can all be useful, but they're not interchangeable. So, for example, in a joint venture or in a long-term commercial arrangement, a mandatory senior executive escalation or a mediation process can sometimes solve a problem before it becomes a formal dispute. At the same time, you want to make sure that parties who are operating in bad faith are not making the most of those, interim procedures. If the client needs urgent relief, you don't want a clause that requires them to wait 60 or 90 days of escalation before anyone can seek even an interim or relief or an injunction. So, you need to be mindful about all those issues. Similarly, expert determination, as I mentioned earlier, can be useful for narrow technical or accounting issues, but the clause needs to be precise. What issues can go to the expert? Is the expert acting as an expert or an arbitrator? Is the decision final and binding? If not, what are the alternative options available to the parties? What are the materials that the expert can consider? What happens if the dispute includes both technical as well as legal issues? In energy deals, especially long-term commercial deals, you'll see arbitration is very attractive because parties want to maintain confidentiality, neutrality, and they want neutrality to be a big part of it. They are normally cross-border enforceability. an LNG terminal may be being developed in Louisiana. The EPC contractor is French, but the JV partners are Japanese, US, and Emirati. And so there are a multitude of parties who just don't want any party to have, some bias built in or embedded. And so in international or multi-jurisdictional deals, you'll see arbitration is preferred because, as I mentioned, you don't want that element of bias if it's happening on one party's home courts. Similarly, arbitration can also make a lot of sense for commercial disputes where the parties want arbitrators with industry or legal expertise. But you can't just say, oh, let's prefer arbitration over litigation because arbitration is faster or cheaper. That's not necessarily the case. It really depends on the clause, the rules, the tribunal, the discovery process, the parties involved, and how the case is managed. So you need to be very intentional about it, Aamir. And so when we choose arbitration, we should do it intentionally and not just because it sounds sophisticated or it was used in another transaction or a precedent document. For choice of law, you're normally thinking about predictability and fit. I remember back in the day, if your LLC was not in Delaware or governed by Delaware law, it was a non-starter. Things are changing now, because the Chancery Court now sort of second guesses what the intention of the parties was. And so a lot of parties are now choosing Texas law or Nevada law. But, again, it depends. Like if it's a finance agreement, parties tend to choose New York. If it's a JV document, parties tend to choose Delaware law just because the case law is that much richer in those jurisdictions. For energy deals, very routine to see Texas as the governing law for parties. But you want to make sure that your choice of law does not have unintended consequences. You want to be mindful about, and I'm going to throw a lot of jargon now, so excuse my legalese, but like some states treat, are pro sandbagging, some are anti sandbagging. By default, some may treat non-competes consequential damages waiver, indemnities, duties waivers, statutes of limitation, and remedies very differently. In some cases, the statute of limitation will be 3 years. In other cases, it's 6 years. And so is 3 years enough time for you to figure out that the rep was materially breached and you don't want to be in a position where you find out in, the fourth year and your statute of limitation has run out. So, you're always considering about those issues as well. I want you to talk more about the forum provision, but just to touch upon that and just to preview, you want to make sure that you align the forum provision with the remedy structure. If the main dispute is subject to arbitration, can a party still go get interim or injunctive relief to a court? If so, which court? And does the clause clearly preserve that right? But I'll conclude this section by just saying, be clear whether the forum is exclusive or non-exclusive. Be clear about arbitral rules, seat, language, venue. Seat and venue, by the way, are very different. That's a great summer associate assignment in case someone's wondering difference between seat and venue. Third would be preserve emergency relief where needed. Fourth, make sure notice and escalation provisions are realistic and do not prejudice your client. And fifth, about enforcement. I think a great award or judgment is not very helpful if you cannot enforce it against the relevant party or assets. It's not going to be worth much if you get a judgment against a foreign entity that has no assets in the US. And so dispute resolution clause should really be designed around the likely failure modes of the deal. I don't know. Would love to hear your thoughts, Aamir.
Yeah, just
This
kind
is
of
really your
expanding
bread and
on.
butter.
Yeah, it is. And just kind of expanding, I'm in complete agreement with everything that you said. I want to expand on a few areas that you were mentioning. So you're talking about kind of Delaware and New York. Right now, they've got an abundance of case law that help parties understand what their rights and responsibilities are, especially with respect to boilerplate language in their contracts. And you and I are both Texas lawyers. This is an area which, over the last few years, the Texas government has made a concerted effort to compete for companies to move to Texas. And in furtherance of that, we created the Texas Business Courts. And though the Texas Business Courts, one of the mandates is that every single decision that they make, they have to send out a written opinion. And this is in contrast to a lot of the Texas state courts where when they hear a motion, they might just say affirmed or denied, or they just might give you a one-line judgment or ruling on whatever it is that you put in front of them to decide. Here, the courts have to have a reasoned written opinion on everything. And this is starting to create this body of law to attract companies into feeling comfortable with the amount of risk that they're taking on in Texas. So historically, in the energy industry, I've seen a lot of arbitration provisions. And I think the basis or the line of thinking there is that arbitration can be faster than a court process. Courts, especially state courts in Texas and state courts elsewhere, are backlogged. And so it can take quite a bit of time to get through your lawsuit to where it's ready for trial and the court's actually ready for a trial on the same case. In an arbitration, you have a little bit more control over who's deciding your dispute. In theory, your arbitrators can have a lot more specialized knowledge over what might be a dispute in the case. I recall one specific arbitration that I was involved in over royalty disputes. And we had our arbitrator, a sole arbitrator, was a former in-house attorney at one of these super major oil and gas companies who had handled a number of royalty disputes over his distinguished career. And so you've got someone, rather than a court in which the judge might just have very general knowledge over a lot of different things, you might have an arbitrator who has much more specialized knowledge into what's at dispute when you're disputing it. Another advantage to arbitration is just being able to keep your documents and information confidential. As a general matter, courts are open, and judges generally want the information filed in court to be open to the public for viewing, and you have to file a motion to seal if there's any confidential documents that you want to be filed, but for nobody to be able to view it. And different judges will have different perspectives, but there's a lot of judges who say, oh, it's your burden of proof to make sure to show that this document shouldn't be open for the public to be able to view, because these are open courts and the public has a right to know what's going on. Energy clients tend to be a little bit sensitive to their information being out in the open, especially when their competitors can then see that information. And energy clients are also, I mean, you mentioned Hamza earlier that a lot of the stuff in the energy industry is newsworthy, and there's a lot of publications that might catch on to different things and different disputes that might be going on, and maybe give more attention to the specific dispute and make it a bigger deal than it might actually be. And energy clients are a little bit sensitive to that and want to make sure that, hey, even if one of the parties who normally we have a great relationship with, maybe we're disagreeing about a certain deal that we're doing together, we don't need this to be in the public eye. It's not that big of a deal. We're going to see this process out and figure it out, and it's nobody else's business. So energy clients are always sensitive to those factors and have historically liked what arbitration has given them. I'm starting to see more and more energy industry clients choose Texas business courts as a venue. The Texas Business Court statute has a mandate for a certain amount of time that disputes are supposed to be resolved in. So it also solves the timing component of the problem that historically has happened with state and federal courts.
And do you think they have adequate expertise in handling those disputes in your experience? Because
Yeah, in
that's
my
another
experience,
big
I mean,
consideration.
the Texas Business Court judges are generally have had a career as business litigators. They've spent decades in the industry. They've seen a number of the disputes that we bring before them. And so you've got much more specialized judges handling these types of cases.
Nice.
I want to move on to kind of our next section. I want to get into a little bit more into some certain contract provisions that we've touched on before, but I want to walk through what they are and how they go about allocating risk. And the three that I've got are kind of your representations and warranties, indemnity provisions, and force majeure. And I know force majeure especially has been in the news a lot lately. I mean, most recently with the closing of the Strait of Hormuz. But we've also had in Texas, we've had a few winter storms that have caused force majeure to be invoked. We've had back in 2020, COVID. Force majeure was talked about a lot during COVID. Why don't you kind of walk us through your thoughts on force majeure and on indemnity and kind of the reps and warranties in a contract and how you go about thinking about them and kind of how all of these events have shaped how you think about them?
Thanks. I think we have like last 13 minutes left. And so it'd be good to know if we have if we are expecting to receive any questions so that we can sort of time ourselves accordingly. So if you have any questions, feel free to send them right now. Otherwise, Aamir and I will keep talking. I love talking about force majeure, Aamir. But like you mentioned,
Actually, Hamza, I'm seeing that there are a couple of questions in the chat. So let me read the first one. It says, from both of your perspectives, are there situations where concerns about cost or anticipated duration of the process or the nature of the relationship between the parties ultimately influence the dispute resolution mechanism that's selected? Do you want to start on that one, or do you want me to?
no, I'm happy to sort of touch on it briefly and then hand it over to you. That's 100% the case. Like in an M&A transaction, for example, as I mentioned, if it's a earnout dispute or if it is earnout is you close and let's say there was a regulatory approval that was pending or there was some metric that was pending at the time of closing, and all of a sudden the company meets that objective, and all of a sudden its value goes up, or it makes a lot more money than it was previously supposed to. The seller is sort of incentivized to then make sure that it chugs along the process so that after closing, both buyer and seller can benefit, and the seller is then paid a certain amount of money, whatever is agreed in the contract, and that's called an earnout. Whereas purchase price adjustment happens at closing. That earnout is future looking, purchase price adjustment is backwards looking. And so between sign and close, how much debt did the company get? What was the net working capital? What was the cash flow situation? Now if there are disputes about those issues, it's not suitable for anyone to be going to a court and having a lengthy dispute about it. You want an accountant to quickly resolve those issues. And so, you have those sort of considerations about cost and anticipated duration of the process and the nature of relationship. You want to keep the purchase price confidential as well. So you don't want to be going into Harris County and publishing it on a docket for the entire world to see. So those are definitely your considerations. Similarly, in an arbitration, if there are multiple parties involved, the nature of the parties mean that you don't want any party to have home advantage. You don't want the commercial terms to be again published. So confidentiality as well as neutrality are two big considerations for parties to choose arbitration, as well as arbitrators are normally from the industry, so they understand that perspective that those industry players are bringing. I hope that answers your question, but Aamir, do you have thoughts on that?
Yeah, just to add to it, I mean, thinking big picture, I mean, when we're putting together one of these commercial agreements, we can be as specific as we want. So we can have a generalized dispute resolution mechanism that just applies to anything, any dispute that might come up. Or as Hamza was mentioning, we might have something that, hey, for this type of a dispute, we might go to arbitration, whereas for all other disputes, we might go to court. It can even get more granular than that. And so depending on the type of deal that might be coming into play, you certainly wouldn't want to be in a situation where you're arbitrating and paying for arbitrators, which can get somewhat expensive, maybe not relative to the total value of a deal, but you certainly wouldn't want to be in a situation where the parties are paying the arbitrators more than is really at stake in the issue. Like you don't want to be arbitrating for the types of clients that we work with a $100,000 value dispute. So there might be a carve out for maybe if we foresee certain types of disputes that are going to be kind of small dollar values in the sense of the overall deal. Maybe we might have a mechanism where we say, okay, the parties are just going to come together and we will figure it out. Either through we're required to negotiate for a certain period or we're going to have a mediation and we're going to hash it out. And then from there, maybe if we're still kind of in a dispute, then from there might be other rights and remedies available to the parties. But with a lot of these deals, the parties are commercially motivated to work together. They all want to make money. And so, I mean, what I see a lot is whenever some of these disputes come up, there's some sort of commercial resolution to the deal. It's like, hey, we still want to work together. I understand that we might have this dispute. You know what? Just in the interest of working together, in the interest of professional courtesy, to resolve this dispute, we'll give you preferred pricing for the next decade. Or something along those lines to where, hey, we're working together in the spirit of compromise, in the spirit of working together. We're going to find a way to kind of set aside our differences, continue working together so we can both make money. We've got one more question in the chat. It says, for someone who's still figuring out whether they're more interested in transactions or litigation, what experiences or opportunities would you encourage them to seek out? Hamza, I'm curious to hear your perspective on this.
That's the age-old question. And to be honest with you, there are no right or wrong answers. The only thing I would say is that if you have whatever underlying tendencies you have, you get the opportunities at both sides, and correct me if I'm wrong, Aamir, to sort of channel them. For example, if you are a good orator, you need those skills when negotiating documents. And that's a lot. I want to say that's very challenging. That's because in litigation, you're appearing before a judge, you're well prepared. In negotiations, you're dealing against sophisticated parties, and both parties are bringing, representing their clients' interest, and you're trying to, you're in a dispute resolution, while you are very civilized, at the end of the day, it has hit the fan. And so you're less, you don't care much about preserving the relationship. But as a transaction attorney, you don't want to be the reason why the deal doesn't go through or it actually hits the fan, right? So, one question you're always asked, no matter where you go in those small conversations, is, if you weren't a lawyer, what would you be? And my answer would always be an investigative journalist. Now, as a transactional attorney, you're being one of the worst things that I thought about being a transactional attorney as a junior lawyer was due diligence. And then writing a due diligence report until I flipped the lens. I'm like, this is exactly what an investigative journalist would do, right? And so I think just like the third thing I would say is, like, as a transaction attorney, like, a senior lawyer said this too, like, one of the best things about his job is, like, he's trying to figure out the puzzle. And like, as soon as you figure it out from that perspective, I know as a young lawyer, as a junior lawyer, you're inundated, you're overwhelmed because this is unlike anything you've ever worked on, the time constraints, the nature of emails, the number of emails. But like, I would say, just realize you have more time than you think you have. And and just understanding the whole structure really sort of helps you get better. And I think, to be honest with you, I think it doesn't matter what you end up choosing, whether it's transactions or litigation, in my view, Aamir. I think if you make a decision eventually, just stick with it. Because the pastures on the other side are always greener. You're always thinking, you'll always have a bad day at work. I think Roger Federer said a great thing that he's only won like 52% of his points compared to his rivals or opponents, but he has just so many more trophies to show for it, because like it, and both him and Djokovic say that what matters is not that you have had a bad day. What matters is how quickly you can recover, come back the next day, and give your 100%. And so at the end of the day, whatever your underlying tendencies are, you'll get to channel them regardless whether whatever you choose or not. And then whatever you choose, just make sure that, you stick with it, because the more repetitions you get, the more reps you get, the better your knowledge and understanding will become, and the better. And once that starts happening, once you start learning where all the pieces fit, you'll just become more and, better at what you do, and you'll start enjoying whatever you do a lot more. What are your thoughts, Aamir?
Yeah, to add to that, I think as a law student, it can be really difficult to understand what lawyers like Hamza and I do. And a key part of just figuring out what you might want to do is figuring out what lawyers who are in these practices do. And also, to put it into context, I mean, Hamza and I do a specific thing within transactional law or within litigation. We both work in the energy industry, and our lives might look a little bit different than, say, a healthcare M&A attorney or a healthcare litigator. Or there's so many different subparts within these broad brushstrokes that might change what your life might look like, the types of things that you're learning about, the types of things that you're fighting about, or the types of deals that you might be doing. So it's really important to get as much exposure and to talk to as many people who are in the industry as possible. And part of it is coming to events like this where you get to hear Hamza and I just talk about what we do for a living, and seeing if that kind of fits what you might want to do for a living. I think also if you have the opportunity to go through a summer program at a full service firm where you generally rotate through a few of their different groups and get to see kind of what their lawyers are doing, what their lives look like, the types of things that they're working on, that can also help shape how you might see your career path going. And so just expose yourself to as much as possible, and hopefully something will resonate with you, and that'll give you some guidance over what you might want to do. All right, we've got our last question of the day, and then I think we are done. Last question is, listening to both of you, it's clear that there is a significant amount of foresight involved in drafting contracts. Is that something that comes with experience, or is there a framework you use when identifying and planning for potential disputes? That question,
100%.
That's all you, Hamza.
100% experience. And the more reps you get, the better your pattern recognition gets. And you're like, ooh, I saw this in a deal 2 years ago. This is how I'd address it. The good thing is when you're starting as a junior associate, nobody is expecting you to come and solve world's problems. And so you'll always have senior lawyers doing strategy. Just make sure in the first 2-3 years, ask as many questions as you want. Be as annoying. Keep picking up people's brains and be like, why did we do that? Why did we do this? And pattern recognition comes a long way. The other thing I would say is, like, the more the world changes, the more it remains the same. And like the more history books you read, you're like, well, the world hasn't changed that much. And like it looks a lot more sophisticated and complicated, and we have put a lot of jargon words around what we do, but like more or less it's pretty much the same how people were doing business back in the day in ancient Rome, or in like at the advent of industrial, in the Gilded Age or in the Industrial Revolution age. So my perspective is like, read books in your spare time, listen to podcasts, because that sort of channels your thinking gears as well, and that gives you perspective and ideas that this is how it happens in this industry, this is how it happens in that industry, and that's how you can add value. But you don't need to do that. That's just how I go about life. But like, what you would need to do is get reps. The more documents you review, the better your fact pattern recognition gets, the smarter you get as a lawyer. At the end of the day, like that's exactly what they're doing in AI as well. Like a training model is literally that they are dumping all those documents and then expecting the algorithm to figure out what's the best way forward. And as a junior lawyer, you are no different. During the training period, you're just getting a dump of all those documents, reviewing precedent documents, seeing how it was done in that deal, in X deal, Y deal, Z deal, and then trying to tailor a situation to the fact pattern that you have before you. What are your thoughts, Aamir?
Yeah, just to add to what you were saying, I think it's important as a lawyer in general to be a lifelong learner. And that a lot of the things that we do, we're constantly building off of our experiences. So a not uncommon situation for a young litigator is to come in and to be working with a partner, and they might say, oh, you know what, I think there's a case or some sort of legal doctrine out there that says XYZ. Why don't you go find an authority that says that? That's a not uncommon experience as a litigator working with a more senior attorney. And the reason why that senior attorney thinks that is because they have these years of experience of seeing different types of disputes, different legal issues, researching it themselves to a point where they've built up a 20, 30-year career, and they've got all of this knowledge in their head of different things that they've worked on that they can pull from to help issue spot or to help think about strategic decisions that might drive a client's decision. And most of the time, like what they were thinking about, you go and you research it and you find it. And it's like, oh yeah, it's exactly what they were saying it was. And so you learn a couple of different ways. One is by doing the work on a given case that you're working on and doing the research and understanding it and building off of concepts that you continue to learn as the years go by. And then also, to add to what Hamza was saying, it's important to have some amount of interest in what you're working on. As a litigator, I'm telling my client's story. Yes, I'm telling it in the framework of a given dispute, but I am limited in my ability to tell my client's story by the extent to which I understand their business and the industry that they operate in. And if I don't really understand that, I can't tell their story. And so part of us being good at our jobs is just being interested in the energy industry and constantly reading about it and staying apprised of the different things that are going on, not just in a legal context, but also in a business context. So, I mean, Hamza and I are both constantly reading news articles, reading different developments in technology, understanding where the market's moving, how businesses are thinking about different things. And that really helps us understand disputes that might come up and how to plan for them. All right. Hamza, unless you have any concluding thoughts, I think that's it for our presentation.